So good morning, everyone. This is the lecture today on the WTO and the trade regime. As you will no doubt know from perhaps the school days, and if not from the readings, this is one of the classic cases of an international regime that has turned into an international organization, or I should rather say where parts of the regime have been formalized into an international organization with a number of consequences and, as it were, disputes. So both the GATT, which was the predecessor of the WTO, or has been merged together with other aspects into the WTO. The GATT was one of those schoolbooks examples of what an international regime is, as a set of principles, norms, rules, and decision-making procedures. And we're going to have to look at the ways in which the restructuring of this into the WTO has raised a number of issues about, in particular, the design of this institution, what it is supposed to achieve, and how it relates to states as the core members of international society and the struggles that then have come about as a consequence. Let us briefly recap the human rights regime that we covered last week. We identified the Second World War and especially the Nazi regime as the point of departure for this human rights regime, the sense that one would have to find a way of making human rights much more central in any post-war world order. This led to the Universal Declaration of Human Rights and then subsequently to covenants on political rights and economic and social rights. And then we've seen from there on a set of other conventions that were then focusing on specific rights, rights of children, etc. We've discussed at length then how in 2006, as part of the post-Cold War seeming consensus on human rights, one aspect was what we discussed was the Vienna Declaration and sort of the idea that human rights are now universal and no longer contested, which we discussed was perhaps a bit premature. And we noted how in the Vienna Declaration there was also this insertion of a regional understanding of human rights. But the other development that we discussed in particular was the move from in 2006 to abandon or abolish the Commission on Human Rights and turn it into a Human Rights Council. And we've seen how this involved a move organizationally from the Economic and Social Committee towards the General Assembly, how it involved the idea that member states could be excluded and how that has actually happened a number of times by a vote in the UN General Assembly. And in particular, we noted that among the procedures, in particular, there has been installed now the idea of a universal periodic review, where the idea is that member states get reviewed every 5 years, and that even though this relies largely on discursive pressure, they are obliged to respond to the claims and questions raised by the member states within this review. We've noted how this is a nested regime. I've already said that there are, beside the Universal Declaration of Human Rights and the two covenants, a whole range of other more specific covenants and conventions. But then we also discussed how, in addition to the global regime, there are regional regimes. And we in particular discussed the differences between the European human rights regime in the European Convention on Human Rights and those in other regions. We discussed these different arrangements in light of the tensions between international and world society, the idea that human rights are guaranteed by states who, at least in accordance with the civil and political rights, are actually supposed to stay out of the individual private life. So those who are actually infringing on human rights are turned into those who are guarding human rights. And of course, that is to do with this problem of squaring the circle, that is giving human rights more universal validity, while at the same time leaving states in place as the main organization of politics. So this has been traditionally solved in favor of international society. So all reforms basically privileged the idea that states are the ones who are at the heart of guaranteeing human rights. There was a partial shift after the Cold War, which we already had discussed in several other lectures, under the term of solidarization. And this was partly then in those human rights violations that are seen to be particularly grave. And this is, of course, things like genocide. And so we installed the International Criminal Court, in a sense, as part of the regime for particular severe human rights violations. We've seen how in Europe we can see a much further deepening, and in particular what distinguishes the European human rights regimes from the others is the direct jurisdiction that the European Court of Human Rights has, whereas in the other regimes, regional regimes, it's more of an advisory function that those equivalent bodies have. We've seen how there continue to be further challenges in developing this human rights regime, making human rights more effective while at the same time safeguarding the rights of states. And we've noted how there are particular tensions in the debates about human rights, both in terms of their inclusiveness and exclusiveness, and in terms of the stress on either negative or positive rights and their regional variations that remain unresolved. With that, let me now turn to a completely different area, although we see some interlinkages because, of course, rights have to do with some of the regulations that come out of the trade regime as well. This is going to be a lecture now in which we discuss some other norms and principles, and they have to do with the idea that trade should be largely liberalized, that everyone should have the right to trade freely across the globe, and that inhibiting trade is to the detriment of the well-being of people, but also ultimately that this is one of the causes of war, that if trade would be allowed to flow freely, there might be less war. And therefore, it is no surprise that the General Agreement on Tariffs and Trade is one of the sets of as part of the set of institutions that has also developed immediately after the end of the Second World War. And this is partly to do with the fact that before the Second World War, most states turned to protectionist policies, and in the competition between states, therefore, trade was severely inhibited. Obviously, the General Agreement on Tariffs and Trade was a Western part of global governance. So during the Cold War, this only applied to the Western world. The Soviet Union and associate states had, of course, a completely different idea of how the economy should actually work. And it's only with in the post-Cold War era that we then see an expansion and a fundamental reform of this agreement. So initially, the idea was even more ambitious already during the Second World War in plans for the post-World War order. The idea was to establish already then an international trade organization, but then that was never realized. And instead, one did what then became subsequently one of the main organizational forms of such cooperation. One agreed on a basic treaty that bears all the resemblances of a regime. So it doesn't have a proper jurisdiction, it doesn't have a secretariat, secretariats are moving, one meets regularly every year to discuss, or every other year to discuss the furthering the regime, furthering the norms. New norms are developing over time, and one does that in these famous rounds. So one starts at a particular place and says, okay, in the next years, we want to establish rules that govern our relations in a particular area, get this right at some point today, in a particular area, and we call this, say, the X round after the place that we start first, and then basically then we continue until we have agreed on a set of rules and specific provisions that then afterwards are considered binding by the states. So this idea of moving on through these intergovernmental meetings in rounds is very obvious in the GATT, but it is also something that has been applied afterwards by all other regimes. So all other regimes will get to know, this includes the climate regime, etc., operate on the basis of its members meeting regularly in order to discuss the furthering of those rules. The principles on which this agreement is based, and one of the reasons why during the Cold War this was limited to the Western world, is the idea that the liberalization of trade, so the reduction of tariffs and other trade barriers, is an essential part that would foster the well-being of people, would provide more welfare, and ultimately also peace. And as part of this, the idea was that there are three principles of non-discrimination. Firstly, there is the most favored nation principle, which means that the conditions that I give to one nation, which are particularly favorable, I will have to apply to all other nations that are states that are part of that regime. So that is the most favored nation principle. Because before that, there were special deals. You could agree special deals with your friends or those who supported you, and that would provide them with privileged access. The members of that regime would then enjoy under the regime exactly those rights and preferences. Secondly, the equality of treatment of nationals and non-nationals. So in accessing the market and being able to sell goods, you cannot discriminate between your own citizens and others. I should say at this moment that the idea that these are principles on which the regime is based, whether or not those principles are actually put into practice is, of course, a different matter. So we're dealing with the abstract principles at the moment, and not all of them have then been applied in all areas. But some of the debates that we're having in these rounds is then how to make these principles operate in different areas and involving different countries, with the additional question of whether there ought to be a differentiation, after all, between countries, because maybe some countries ought to have specific privileges, in particular because they are considered developing countries, and therefore, if you opened up these principles to everyone in the same way, that they would be at a severe disadvantage. So what we're talking about at the moment is the basic principles of the regime that we are working towards within the regime, but not necessarily the rules yet. So three forms of non-discrimination: the most favored nation principle, the equality of treatment of nationals and non-nationals, and then the elimination of quantitative restrictions, because one of the ways of discriminating was that there were quotas that you were only able to import a certain number of bananas, a famous example. And there you can see that, again, because there's been lots of disputes over this, that the elimination of quotas is by no means something that has been achieved. But there are certain goods where the member states still say, we have not reached an agreement on abolishing these elimination of quantitative restrictions. But in principle, these are three forms of non-discrimination, of discrimination that ought to be abolished. One form is that I provide specific special favorable tariffs conditions for some states. Another one is that I privilege my own citizens over others. And a third one is I put limits to the number of goods that can be imported. And the idea is that this is applying to all. So the idea is one of mutual reciprocity within the regime. So we all agree to do this mutually, and that there are exceptions, but those exceptions need to be justified. And normally a justification is that a state is not yet in a position to compete on the market freely with others or requires particular support. On that note, there were 7 tariff reductions in different rounds between the founding of the regime in 1949, so when the regime was ratified and came into force, and 1979. So there was a slow extension from basically a hardcore of material goods that were shipped from one place to another to other goods. There was an extension of inclusion of non-tariff barriers, because while initially the idea was to focus on tariffs, so money that you had to pay in order to be able to import something, to export something into another country, then one realized that perhaps there are other hindrances to trade, and that is because states then could sort of come up with some sort of regulations, often saying this is our certain health and safety standards, and therefore you must also comply with those. And then, of course, you can see that there are, of course, always disputes about whether those health and safety standards are actually required, or are they part of a more cultural background, or are they actually simply there in order to avoid the situation that other states can actually export goods into your country. But overall, the focus remained in these expansions on goods that you had to move from state A to state B. So goods that had to physically be brought across the border. Subsequently, after this set of a range of tariff reductions, what happened was that the states met in Uruguay, and this is why the subsequent round was called the Uruguay round. And this basically lasted from 1986 to 1994, and you can see that this is, of course, the period in which the world significantly changed. So the Uruguay round was basically part of broader developments that included, of course, also the end of the Cold War. And the aim of that round was to significantly extend, deepen, and preserve GATT, and among other things, to extend the agreements to perhaps things that do not have to be moved from one country to another. This, of course, particularly related to things like services. Services do not necessarily have to be physically moved, especially with the development of internet, etc. You could provide services in one country, and then people would benefit from these services in other countries. So what happened was that the GATT was basically left intact. So one moved the GATT into a new umbrella organization, WTO, which then did especially 2 things. It added other things to the GATT, so it added other pillars to the GATT. It's a bit like in the European Union, which of course developed in the same time. So we will discuss next week how the European Union was basically taking the European communities, and particularly the European Economic Community with a single market, and added cooperation in justice and home affairs and cooperation in foreign policy to that core. And likewise here we took the GATT, which was focusing on tariffs and trade, largely for goods that need to be transported from A to B, and added an agreement on trade and services, and added something that was called trade-related aspects of intellectual property rights, because one of the things that the states agreed on was that there was an issue that if there was no international regulation of intellectual property rights, that one problem was that other states could simply copy particular developments of machines or patents in other countries without being punished, but they wouldn't have to, of course, invest the money in developing those patents and inventions, and that therefore there was a problem that they could then sell the goods much more cheaply because they didn't have to bear the cost of developing those rights. Now, as you all know, this last aspect is one of the most contested ones, because this raises issues about the possibilities or the capabilities you have to actually develop particular new inventions, whereas there may be states who are structurally in such a position that they cannot do this, and therefore the debate is, of course, about the legitimacy in terms of the justice of that aspect of the WTO TRIPS. But also then the question of under which conditions can you do exceptions to that basic rule. The second aspect, though, that the WTO did largely within GATT was a formalization, a centralization, and juridification of the WTO. And one of the things that we're talking about now, we're going to talk about extensively, is the development of an arbitration system and a kind of court that would then come to binding judgments in case of disputes between member states. So the newly found organization, and this is from the WTO's website, had a number of functions which are quite typical for the secretariats, if you will, of those organizations. They have to perform particular aspects, they have to their practices, and they have to deliver particular goods for the function, fulfill some functions. One is to administer the existing trade agreements, to monitor, to collect data, etc. Secondly, to act as a forum for trade negotiations. These are the rounds. So within the WTO now, the WTO's task is to provide a forum in which those rounds can be held and to organize them. The third one is to settle trade disputes. This is about this appellate court, and we will get to know this as the dispute settlement mechanism, where the members of the WTO sit as the dispute settlement body. Fourthly, to review national trade policies. This will be a standard feature. We've already seen this in the human rights regime, in the Universal Periodic Review. So the function of the WTO is to review trade policies and then tell states where they are perhaps in conflict with existing regulations. Fifthly, to assist developing countries in trade policy issues through technical assistance and training programs. And finally, to cooperate with other international organizations. This is a function that you can see on all of these slides to come, and in the lectures to come, whenever we're going to talk about the functions of the main body of the organization. It's to cooperate with other international organizations, and that may be a trivial point, but is of course an important point, so that the different parts of global governance are not moving in completely different directions and possibly undermining each other. You can see that a large bulk of states are now members of the WTO, with the head office in Geneva, and a Nigerian Directorate General, a Nigerian woman, has been there since 2021. So this means that some of the basic procedures in accordance with those functions are the negotiation rounds, where currently in the so-called Doha round. I'm going to talk about this in a moment. We've been in a Doha round for a substantial time, and you can see, therefore, there are significant disputes that prevent the Doha round from, at the moment, furthering the development of rules significantly. The reviews are taking place through particular committees that the WTO forms. The jurisdiction is taking place in the dispute settlement body, and the information is done through trainings in developing countries. Again, these things are always difficult to put on a slide, so I encourage you to go to the WTO's website, but you can see that essentially there are these main bodies are for the different parts of the different pillars of the WTO. You can see there's the Council for Trading Goods, then there's a Council for Trade-related aspects of intellectual property rights, and there's a Council for Trade in Services. This is corresponding to the three different pillars of the WTO. You can also see then that there is the ministerial conference, which meets both as a general council. So this is basically when they meet all together, but it also meets as a review body where the member states' policies are reviewed, and it meets as the dispute settlement body. So in principle, in the settlement body, all member states are there. But then, of course, we will see how there are subcommittees, if you will, and these subcommittees then do the rulings. So let me turn then to this major aspect of the WTO, which is both, in a sense, the most successful part of the WTO, and at the same time, at the moment, as you might know, defunct. This is the dispute settlement mechanism. The dispute settlement mechanism is the part of the WTO that is, in a sense, the jurisdiction, with states as parties. So we're not talking about individual companies that are taken to court there. This is about states violating the principles, not so much the principles, but the ways in which the principles are codified in the treaties that establish the WTO and the subsequent agreements, and so therefore how the rules have been developed. And if a state feels that another state has unfairly not followed the non-discriminative principles, so for instance has imposed tariffs that the state thinks are in an area where we have an agreement that those tariffs should not exist, the state can report a breach of contract to the WTO. And in the first instance, the procedure is geared towards a mutual agreement. So the idea is that before now proper legal proceedings are started, under the guidance of the Secretariat, there are negotiations between the conflicting parties, and ideally they would settle the issue sort of outside the court proceedings, if you will, outside what follows then. So part of the dispute settlement mechanism is that you start first with finding a solution without involving judges or any other kind of binding rulings. And about a third of the disputes are then solved. You've got 30 days to do that. In the other cases, there is no resolution to the dispute. And this then means that the WTO establishes so-called expert panels. There's a list that the WTO has of nominees from member states, experts, and there are then panels. They have to be an uneven number in order to avoid sort of 2-to-2 kind of situation. So there have got to be an uneven number, and they are then appointed. And again, it's not sort of directed as a sort of that you work against the states. They are appointed from the list in consultation with the conflicting parties. So in a sense, this is still part of a deliberative process, if you will, except that in this case, now the expert panel will try and find a solution to the problem. They will therefore issue a recommendation, and now there is a significant change in the practice of global governance. In most other organizations that we know, what happens is that those recommendations will then have to be adopted. And if you've got more supranational arrangements, they are adopted by something like a qualified majority. This is normally the case in, say, the European Union at the heart. Right? You've got a qualified majority. Mostly, though, in intergovernmental organizations, everyone has to agree. So that means that you can veto the recommendation. And so what happened in the GATT before the WTO was established is that the party that was charged with having breached the rules would normally then say, "Oh, I veto the agreement or the suggested resolution." This has been reversed in the WTO in order. So you can see what you want to achieve is you want to achieve the further credibility of the bargains that you've made, and this leads Coramenos et al. To further centralization and therefore to further supranationalization. And the supranationalization in this context consists of the fact that you can only reject with unanimity. So before you had to approve with unanimity, now you can only reject with unanimity. So the state who is charged with having breached the rules would have to get everyone else on the side, and this is of course very unlikely. So the ruling is, or the opinion of the consultative body is approved if basically there is no unanimity against. But this is a reversal of the unanimity rule, not unanimity in favor, but unanimity against. Now, of course, the state then might still think they disagree. And like in normal court cases, it can then appeal the decision. And this is the moment when a more court-like structure, so rather than this being based on some sort of deliberation, a proper court-like structure comes into being. And the court-like structure is the so-called appellate body. The appellate body consists of 7 judges that are appointed for 4 years. And they are appointed, though, by unanimity. And this is an important aspect because this causes the problem at the moment. So they are appointed by unanimity. So until the 2000s, it was not, the 2010s, it was not, well, actually the whole problem started already in 2007, but for some time, what happened was that experts would be nominated by states, and the US would normally have the right to nominate at least one state, EU, and so on. But then basically there was an agreement among the states that these were experts, and that we basically sort of approved them. Those 7 judges, then, if a state is unhappy with the recommendation of the expert group at the expert panel, the appellate body will then basically rule on the disagreement. And if basically the appellate body finds that one member state has breached the rules, the mechanism is then to allow the other state that has brought the case forward to adopt punitive tariffs. So in other words, that the tariffs would then be justified because obviously the court has found that the other party has been in breach of the rules. And this has been for some time a highly effective mechanism. So while after the Uruguay round and the Doha round, the furthering of the rules has come to deep waters because of the issues at stake where member states could not agree, the appellate body, or this whole dispute settlement mechanism, became a rather effective tool to govern trade relations. So states would continuously actually take things to the dispute settlement body, and there's a whole range of issues that different states, the EU and the US and the US and China and the EU, they were constantly basically taking each other to court. And then basically waiting for the dispute settlement mechanism either to produce an accepted outcome before, or then go to the appellate body, which will then basically rule on the matter. And then basically this was then widely accepted. The problem occurred with, in particular, the United States increasingly being unhappy with the rulings of the court. And they had two problems. They first, in general, thought that the court was biased against the United States and gave too much rights to in particular, countries like China. Now, one of the problems with China is when China became a member of the WTO, because China is still classified as a developing state under the UN sort of classifications. The problem was that it was exempt from a number of rules. Now, in the negotiations for becoming a member, China accepted a lot of other rules within the WTO that it would normally not have to have accepted as a developing country, and they did so. But still, it doesn't. Not all of the rules apply in the same way. So, in particular, support for domestic industries, for instance, is allowed a lot more than say for other industrialized members. This has led to a situation, as China was developing further, that the US was finding that the rulings were inappropriate. But of course, that part was not so much about the rulings itself. It was perhaps more about the fundamental rules of the WTO. And they thought also that as always, those courts tended then to expand their scope, and ruling followed after ruling. And the United States thought that that therefore the appellate body was overstepping its competencies. And what happened then, so this started already in the 2000s. Towards the end of the 2000s, the US started to raise questions. There was a South Korean that was nominated to become a member of the appellate body, where the United States was unhappy because that person had criticized the WTO for basically being biased against the developing countries. And so the United States thought that wasn't a particularly good candidate for them, and so they blocked that. And so there was a number of delays in getting the appellate body off the ground, as it were, because the United States basically vetoed the appointment of particular judges. And under Trump, then under the first Trump presidency, this led to a situation where too many of the open positions were blocked, and therefore the appellate body was no longer functional. There were not enough judges to sit in the proceedings. And the Biden administration has in fact not changed that policy. So the United States has continued to block the appointment of judges. Now, there are I suppose there are three aspects, on that consequences that follow from that. So firstly, at the moment, there is no appellate body. So there is no body that, if you take the United States to court, there is no place to go, as it were. So there are still cases brought forward under the dispute settlement mechanism, but they stop basically at the expert panel. And then if the parties are not in agreement, and if one of the parties involves the United States, there is no place to go. So so people do appeal, states do appeal, but there is no court that could then find. So there's a whole list of appeals open in the WTO. Secondly, so this was one. So the appellate body. So it's actually already two. So the appellate body is not operational. And secondly, this doesn't mean that there are no appeals. It's just that so that they're just not heard. However, in order to sort of find a way out of the situation, there are basically 53 member states. You've got to see that in the EU, trade policy is a competence of the EU level. And so therefore, the EU is a member of the WTO on behalf, as it were, of the member states of the European Union. And so de facto, when it says here EU and 26 other states, it's 53 states that have formed an alternative arrangement, so to speak, which they can do under the WTO rules, and this is the so-called multi-party interim appeal arbitration arrangement, which means that these parties have decided that if there are disputes amongst them, they're going to elect 10 judges, and those 10 judges are basically continuing with the proceedings. This is interesting because it does show that most of the states that are members of the WTO find the appellate court and the whole dispute settlement mechanism still a highly useful way of settling disputes. And it's also interesting because among those 53 countries is China. So we talk about all sorts of, disputes between China and the West, but things are actually sometimes a little bit more complicated. And when it comes to the workings of the WTO, the EU is actually in agreement with China. So there are at the moment negotiations of reforming the appellate body and bringing the US back into the system. But the ways in which things are going at the moment, the appellate court is not working, but there are alternative arrangements. In addition to the multi-party interim arbitration arrangement, there is also a proviso in the WTO rules that states can actually can settle their disputes by appointing judges themselves. So Turkey, for instance, is not part of the multi-party interim appeal arbitration arrangement, but there's been disputes between the EU and Turkey which have been settled by an agreement between Turkey and the EU to appoint external judges, so to speak, to find a way out. Okay, so one of the main differences between the GATT and the WTO, which marks it out as an organization that is going beyond normal intergovernmental arrangements, is the dispute settlement mechanism. And it goes beyond normal intergovernmental arrangements, both in the reversal of unanimity, in the adoption or rather rejection of the findings of the expert panels, and it goes beyond the normal settings of intergovernmentality by installing this appellate body. And we've seen how, even though this is at the moment dysfunctional, that states find that so valuable in maintaining the credibility of the rules that they have actually created alternative mechanisms in order to maintain that sort of function of the WTO. The second addition was the trade-related aspects of intellectual property rights. This involves an obligation to appropriately protect intellectual property. For instance, a copyright of creative activity. This includes software for at least 50 years, the protection of design patterns for at least 10 years, the protection and limitation of regional indication of source. These are exceptions, so to speak, of free trading. So that is why lots of regions are now finding all sorts of produce that they want to protect. So they want to say you cannot sell a particular good. My Cypriot friend is missing today. Halloumi, for instance, you cannot sell halloumi if it's not produced in Cyprus. Or you cannot sell Black Forest ham if it's not produced in the Black Forest. And there are delimitations of those kind of regions. And you can only sell that good under that label if it's sold at Camembert or what have you. You all know that, and you all know that this is sort of one mechanism now of protectionism, so to speak. Yeah, so it is within the rules, but it sort of means that that there's a certain copyright, if you will, and this copyright is, in a sense, doesn't cease to exist. So if you've got that region, you have the copyright for particular goods. I don't know whether you knew that, for instance, in the case of the Black Forest ham, I always thought that it is to do with the pigs that you slaughter, but the pigs can come from anywhere. It's only the smoking of the ham that needs to be done in the Black Forest, presumably because of the special quality of the fir trees or what have you. Industrial property rights for at least 20 years, and this is the point where there's been the most of the disputes, because a lot of these things have to do with, well, basically this is largely about pharmaceuticals. And in pharmaceuticals, there have been two issues at hand. One of them is to do with sort of where does a pharmaceutical start? And a patent start, and where is it simply something that nature delivers anyway? And this is sort of, there's a gray zone. The Germans amongst you, and perhaps others as well, I don't know how widely this is used, may know a particular liquid that you can take against cough and infections of the respiratory system, this has this unspeakable name that is in the advertisements. It says something along the lines, it's unspeakable, but it can make you speak, or something like that. The problem with that particular issue is that it is made essentially out of some part of the tree. I think it's the rind of the tree. And the question is, of course, then, you know, is that not something, because this has been used by indigenous people in Africa for a long time, so should this be patented? And you can see, therefore, this is a very difficult matter to decide to what extent is something the property, as it were, of a particular company for 20 years, or is it something that is out there anyway? So the exception, theoretically speaking, is if you are basically only taking a flower and use this as a medicine, you have no right to patent that. But as we can see in that particular liquid, there is, you know, a bit of a problematic border there. Secondly, there are exceptions regarding the problem that you may, if you follow that rule of industrial property rights in pharmaceuticals, that at the end of the day you may exclude part of the people from having access to particular health treatments and vaccinations. And this has been debated again in relation to COVID in particular. And the solution for this within TRIPS is that TRIPS allows so-called compulsory licenses. These are licenses that are given under certain conditions, or can be given to producers in developing countries against the will, or you don't have to ask for the agreement of the original patent holder. So this is one of the areas in which being classified as a developing country under the classification of the UN, under the least development countries, where if you're listed there, that gives you, in a sense, I wouldn't call it an advantage, but gives you a possibility to issue such a compulsory license, and therefore allow your own producer to produce, or to copy, as it were, a particular treatment. In 2001, in the Doha round, there was an agreement on this, to actually issue those compulsory licenses, to use to provide some flexibility on those industrial property rights and the measures to protect public health until 2033. And basically, so therefore, there are issues about, production, and then also because the production is not only for your own country, other least developed countries can also import the good from another least developed country which has been producing this under a compulsory license. So this brings us to the Doha round and the problem of what is negotiated there in particular, and why, since the Uruguay round and the installment of the WTO, we've made not so much progress. So in the WTO conference and in Doha in 2001, there was another initiation of new negotiations that basically was trying to enlarge the competence of the WTO further beyond the physical goods that need to be transported from state A to state B. So therefore, there was an expansion which Alistair Young once distinguished into what was called commercial policy and social trade policy. I'll quickly go to this slide because this is Alistair's table. So the question is, are they addressing on the one hand issues of competition or market failures? So the problem was that there may be issues that are trade related, but they're not really strictly speaking to do with competition, but there's a sense that the market will not solve it all, and therefore a requirement to regulate certain areas that are to do with the production of particular goods. But these regulations, of course, have an effect on the market, because at the end of the day, they discriminate your own producers, or those that do not, or vice versa, those that do not follow those rules may have an advantage in the market because they can produce their goods more cheaply. And if you don't regulate that, that means, of course, that because they fall under the non-discrimination clauses, those who can produce the goods more cheaply can then also sell it more cheaply in your own market, and then therefore can undermine the regulations. And these are, of course, largely environmental and sort of protection of workers kind of regulations. So this is what, if you go to market failure, and to questions that, so, and then the second dimension, I should say this first, is that so there are two different, as we already noted, there are two different trade policies that relate to issues that happen at the border. So something has to go beyond the border, and so at the border tariffs are imposed or what have you. But there are also issues to do with issues behind borders. So regulating services is something that nothing has to cross the border, technically speaking. So you've got to do regulations within states. And the same applies, of course, to what Alistair has called here social trade policy. So in that sense, Doha is largely about two aspects. One is about competitive aspects of behind the border things. And this in particular includes things like subsidies. So subsidies are, of course, a problem for trade, because again, if the state interferes with the market by providing subsidies, the producers can sell those goods that have been subsidized more cheaply. And therefore, you want to ideally avoid all subsidies, but then subsidies may be necessary and are common policy instruments for states to safeguard workplaces, to safeguard particular what is considered essential industries, or for instance, safeguard agriculture, which is still seen as something vital for states to have. So there's a whole raft of these kind of aspects, and then there is the issue of market of accommodating or dealing with issues of market failure, which also necessitates discussions. And you can already sense where the problem now lies, and the problem partly lies that there is a sort of global north-south split. This is perhaps of an oversimplification, but by and large, WTO members from the Global South have been interested in commercial policy, in particular in reducing subsidies, in particular reducing subsidies for agricultural products, whereas the Global North has been, in particular the EU, has been insistent on social trade policy because, you know, obviously there are regulations, environmental and workplace regulations that are not the same in other countries, and so the EU has been particularly concerned about that. And this is essentially, therefore, the main issue in Doha is elimination of subsidies, especially in agriculture, and compliance with standards in working conditions and environmental regulations. We already saw that not all of this is new. So TRIPS dealt with some of commercial policies, with the services and patent parts of the services. That's, of course, only one aspect of what services need to look at. And so we've seen ever since, so in previous lectures, you see this started in 2001. So in previous lectures, I had sort of listed what happened in each of the WTO meetings. But what you will see is that after each meeting, normally there is this sort of sense that, oh, we've now managed a breakthrough. And then when you look at the document, you will see, where the hell is the breakthrough? Yeah? So it was basically, there was no breakthrough, and things that have been settled were sort of minor issues and were largely actually issues related to traditional problems of across the border, at the border problems of tariff reduction. And so I stopped now, you know, so I'm now starting in 2017, and I will probably at some point have to delete that as well. But you can see some of the sort of the kind of agreements that comes out of this. So, for instance, at these WTO meetings, the standard is that they confirm that they want to find a solution. So this is a typical sort of issue. So they know there is a problem. They confirm that we've got to tackle the problem, but they haven't found a solution yet. So they praise themselves for, you know, reconfirming the aim to limit, in this case, subsidies for fisheries. An agreement to continue and reinvigorate work on a work program. This is sort of a typical thing they do. This is about electronic commerce, not to impose customs duties on electronic transmissions. I mean, this is, you know, electronic transmissions don't have to go from one, are difficult to manage in terms of them physically, but, you know, how do you deal with this? Anyway. And then, you know, continued examinations of how to deal with TRIPS complaints. So because it's such a contested area, there are disputes over how they should be adjudicated, etc. So you see my exclamation and question marks around this. And then what happened that they said they would meet again in 2020. So this was already later than normally planned. And then they couldn't meet because of COVID. And so they postponed this. So they met again in 2022. Actually, I should also say, I think it was in 17, I switched on the radio in the morning, and it said that it was in the news, in the main news on the radio, that the WTO had a major breakthrough. And what's very interesting was, this is a lesson about journalism, none of the reports could actually identify what the breakthrough was. They simply reported the press statement that the WTO gave them, that there was a major breakthrough and a trade would be changed forever or whatever. But there was no substance to this at all. Sorry. Then they met again in 22, and so they did do an agreement on fishery subsidies, and this is both taking into account environmental sustainability, but also the rights of states that are in the global south and perhaps do not have fishery fleets that can compete with the fishing of the north. So this is about trying to limit the fish that can be harvested, it's a strange term, and access rights. But you can see here that one of the problems is, in order for these things, as you know, in order for international treaties and agreements to become effective, there is normally a threshold that a certain number of states must actually ratify the agreement. So states sign, and then it has to be ratified within the national processes. And you can see that as of today, 61 states have only ratified, but this is far from the 2/3 that would be necessary within the WTO. And you can see that the agreement has been ratified by those states that are blue, but not by the ones that are white. And, the interesting thing is that it's not the sort of Russia and China versus the West problem here. It's Russia and China ratifying with the EU and the United States, but many countries in Latin America, Africa, or South Asia not signing and agreeing to the agreement as yet. There was also in 22 a waiver of requirements under TRIPS concerning the need for compulsory licenses for the production of COVID-19 vaccines. So this was the idea that you could actually produce them without going through the WTO procedures and being formally allowed to do a compulsory license. This was an agreement actually where Germany played a very unhelpful part, because Germany for a long time insisted that the WTO rules would be maintained in COVID-19 vaccines, and then therefore it blocked via the EU those negotiations. And we can of course easily see why Germany did that, because the patents were developed in Germany for those vaccines, or at least for some of those vaccines. There are other aspects that Geneva did, the possibility of emergency responses to global food insecurity, so that the WTO rules would not apply if there was a health emergency, there was a food emergency. An agreement to review, then there was an agreement to review, this is the standard thing, and we're still with that, an agreement to review the WTO's functions, and in particular the dispute settlement mechanism, to make that work again. And so in early 24, at some point they shifted from late in the year to early in the year. There was a WTO ministerial conference after 2 years again in Abu Dhabi. They confirmed in the dispute settlement reform that the aim is to have a fully and well-functioned dispute settlement system by the end of 2024. I have no further intelligence on this, but my understanding is that this is not successful, has not been successful. They decided that they wanted to strengthen the regulatory cooperation to reduce technical barriers. This is again agreeing to work on something. And there is also a joint ministerial declaration on investment facilitation for development. This is about regulating investment flows to facilitate them, but also in particular to adopt particular standards that developing countries need to follow then in order to make investment more transparent and more safe, so for those who invest as well. Again, there was an agreement, but this agreement at the moment has a status of a plurilateral agreement, so not all states agreed to this. So it's an agreement among the majority of states, and at the moment outside the WTO rules. And so again, the idea is so they are calling for an incorporation into WTO documents. And what we see in all of this is that the WTO was originally in the Uruguay round and before the GATT was crucial for norm development, in liberalizing the market, in protecting property rights, etc. So this was one of the main tasks, as it were, of the GATT. This has turned around where it's actually where norm development has come into difficulty, and where the main function of the WTO is actually to adjudicate between the disputing parties. And we've seen how that is now blocked by the United States, but other member states have found ways around that, trying to move on, while at the same time, of course, because of the US being such an important trading partner, that the US that one wants to bring them back in by trying to find a solution to the rules. Another aspect is the exceptions for developing countries, which, however, as we've seen, are most of the time not exceptions in principle, but are temporary exceptions that have to be renewed so that there is no fundamental departure from the liberal market model. When we look at this from the point of view of primary institutions, we can, of course, in the first instance, discuss the degree to which in the WTO trade is used as something that through which the states deal with their relations. But of course, as a matter of fact, I would say that this is a relatively weak case. So even though we are in the policy area of trade, we don't see necessarily the trade as a prime institution. So it's not, trade is not used here necessarily as a practice for states to regulate relations with each other. It's a policy area where states use diplomacy and international law as prime institutions to regulate that policy area. There are, of course, aspects of sanctions and the idea that trade is actually fostering peace and order, but this is actually relatively weak in the WTO. The main, what we find as prime institutions is international law, diplomacy, and trade perhaps again as an alternative of war, that one sort of engages with conflicts via trade. But again, the WTO is more about outruling these and trying to sort of use the principles of non-discrimination. So I would say really it's not, if you look for trade as a prime institution, I think it's more likely that we will find trade as a primary institution in human rights, where states turn to sanctions in responses to human rights violations and therefore use a trade mechanism in order to deal with each other. Then here, where it's a policy field that is regulated via states turning to the prime institutions of international law and diplomacy. If you want to explain the development of the WTO, we've already seen that now two things come together. One is, again, the normative situation of the post-Second World War era, where, in a sense, the idea was that we need to safeguard a particular liberal order and therefore have this trade arrangement in order to prevent war. So it's a trend against the neo-mercantilism that prevailed and its protectionist measures that prevailed before the Second World War. And of course, it has to be said that a fundamental issue, of course, is that this whole regime only makes sense if you fundamentally believe that trade actually produces greater welfare and ultimately perhaps also contributes to peace. If you don't believe that this is the case, then the trade regime loses its significance. So the development of the regime is dependent on these principles that are the fundament of the regime, and disagreement about these principles. And it seems that the current US president, or the incoming rather US president, doesn't quite believe in the same kind of idea of trade than other member states of the WTO believe in. And that, of course, then means that the regime is in difficult waters because one of its main members may contest it. The design of this is, of course, an effect of member states' interests and particular states being particularly powerful. So we can see how the US was able to, in the negotiations, to enshrine particular principles together with its partners in the GATT. But then even afterwards, the negotiations between the states, and you can see when China became a member that on the one hand, China had a great interest now because it wanted to export its goods to become a member of the WTO, and so the others were able to negotiate. China, even though being classified a developing country, negotiate particular agreement with the rules that, including patent rights, that it otherwise would have not been had to follow. The impact of the WTO is to some extent contested. One of the problems of why it is contested and to the extent to which it actually has led to an intensification of trade is because there are a number of other factors that are also at play. So one of the reasons this is contested is that in the history of the regime, most of the countries that were part of the GATT at least were actually also democracies and were inclined to trade with each other anyway, so that there is perhaps the problem of too many factors all pointing in the same direction. But no doubt, the dispute settlement brought function is perhaps the least important now in a reversal of what used to be there before. The question of whether the WTO contributes to peace is absolutely disputed, and of course the problem there is that how would you actually properly measure that? The Barbieri calls this a liberal illusion, and refers to the high interdependency of the interwar period, when there was a heavy trade interdependence already then, and nonetheless we saw the Second World War appearing. But one of the reasons, therefore, or one of the arguments here is that trade actually doesn't make peace. So that is why also the argument of change through trade, which was for sort of informing the Germany's policies in particular towards Russia in terms of gas, that in itself is not sufficient, partly because, of course, it's a question of the interdependency itself being lopsided, but also already from the interwar years onwards, one figured that it's not trade in itself, but it's the institutions that matter. And to the extent that those institutions are also in deep waters, then the peacemaking function is also undermined. So if those institutions do no longer have the power, or undermined by the actors, that significantly undermines one of the ways in which such institutions may actually foster cooperation. The importance of the institutions can be exemplified by one particular, perhaps counterintuitive aspect. I talked earlier about the disputes between the dispute settlement mechanism, about the appeals to court, and you can actually go and on the WTO website and on the slide that dealt with the DSM, I had the link to that website, and you can see who sued whom in the course of the history of the WTO. And one of the interesting things in that is that Russia has made very little use of that mechanism. Now, of course, it's granted of all the members, Russia is one of the latecomers, but nonetheless, it is perhaps intriguing that Russia has had very few cases. So this is, the Russia taking others to the WSM. This is the EU taking others to the WSM, and even if you account for the EU being a member of the WTO for much longer, I mean, the EU has taken everyone to court basically, and there's been a lot of disputes. And you can, of course, this is not to say that the EU has been more sort of aggressive or whatever. So, but what I'm saying is this is a matter of institutional involvement. So the EU, but also China, has been involved in the institution a lot more than Russia has. And so it has not, so this is where the institution matters. And one of the things that was perhaps a failure was that we were not so, that Russia perhaps didn't want, and the others were not successful in integrating Russia as much into the regime, that it would actually take the institution seriously and engage with it. So having more disputes in the dispute settlement mechanism, ironically, is perhaps an indicator for being more integrated into the regime. Because if you use the courts, then you believe in them, so to speak. You believe in the structures of the organization. Legitimization, of course, happens via states. States are the ones that foster the regime, that are in the ministerial conference, that are in the dispute settlement mechanism, etc. And otherwise, basically, it's only via output. So if you look at the things that where the WTO says the 10 things the WTO can do, brackets for you, I suppose, is the idea, then it will all be about the things that we've already discussed: welfare, peace, etc. Protect development. So this is largely a typical organization that legitimizes itself towards world society via welfare through an expert-oriented technocratic regime. Remember that the dispute settlement body works through the expert panels and through judges, which are experts that are installed by the member states, but they are actually not lawyers necessarily. They are trade experts that can be lawyers, but not necessarily. So this is an issue that is regulated via experts, where democracy is not an essential part of the deal. There is a correlation perhaps between liberal trade and democracy, but democracy itself is of course rather a problem, because if those experts do rulings that are against the majority in a particular country, this creates problems. And in particular, of course, it outrules the idea that there should be something like a national interest. So if the national interest does not match with the liberal agenda, like America first or EU first or whatever we might have, this sort of undermines the whole idea of the WTO. So legitimization, therefore, is input via states, and it is otherwise rests on output. And in order to believe the output, or in order to buy that, you need to actually buy the ideas of liberalism, that the market is an area of experts, and that the market is good for the output. Now, because of some of the continuing inhibitions of the limits, rather of the WTO, states have recently turned, not recently, over the last 20 years, have turned into finding agreements that are regional and extend the rules to other areas and provide basically free market access overall. The WTO does allow for regions to go further than the WTO itself. One of the most hotly debated agreements is the so-called Transatlantic Trade and Investment Partnership, an agreement between the EU and the US, which has been under negotiation since 2013. And first, it was the EU member states that didn't quite want that, or perhaps also the populations, and there were massive disputes over this in EU countries. And then with Trump, then he didn't want that. And so I suppose there will be no progress in the negotiations over the next 4 years. You may have heard that the EU actually signed an agreement with Mercosur last week, but that needs to still be ratified, and there are big question marks over whether the member states of the EU will actually approve the agreement. TTIP is sort of one of the pilots of this, and therefore I still leave this in here because it demonstrates some core problems. You see 3 pillars: market access, regulatory coherence, cooperation, joint rulemaking when it comes to things like consumer protection, so that the whole agreement cannot be sort of undermined by cases for consumer protection in one state. So that needs to be sort of therefore moved to the TTIP level. And we can see that there are a number of problems that have been put forward. One is, because this is all expert-driven, the regime is expert-driven, the negotiations are very often behind closed doors amongst experts. And so the secrecy of negotiations has been one issue. There's been an issue that, again, the TTIP would, have something like an arbitration court. And the problem of the arbitration court will, of course, be that it infringes on self-determination through democracy, because the arbitration court, of course, would be a binding agreement like the appellate court is in the WTO. But perhaps the first thing here is a most vital one. TTIP is a fantastic story about the different cultures in regulatory standards. So civil society on both sides of the Atlantic has been up in arms against this, but for very different reasons. And the famous chicken that contains chlorine is, very much contested on the European side, whereas in North America, no one really bothers about that. So there are different standards of regulation that have become part of the culture of societies, which have raised particularly difficult issues when it comes to liberalizing the market with those goods which are regulated because of consumer protection in one of the countries. And this, of course, therefore also means that to move consumer protection onto the level of the regime is highly difficult if you have very competing visions of what that consumer protection should be about. So you've got the problem about, output versus input. So this is the problem of transparency. You've got a problem that of different output norms. And you've got a problem of a de-alignment between the economic processes that are transnational and the constitution in states. This is the typical international versus world society problem. Similar problems, and I've got to be very brief now on this, are about the disputes between China, the US, and the EU, which I think are to do with a whole raft of problems. I mean, so it's not only one or the other, and both sides, in particular the US and China, are a problem here. So one problem is the issue of the status of China as a developing country, and the problem that most of the industries are heavily subsidized and state-led, and therefore there is an uneven playing field. There's also the issue of trade imbalances that are also related to the regulation of currency flows, and the Chinese currency is not freely traded on the market, and therefore you can make your goods cheaper or more expensive via the regulation of the currency exchange rate. Thirdly, the limited access to the Chinese market. The problem is that if you want to invest in China, that you've got to do this with a Chinese partner. You cannot just simply sort of say, I'm going to now produce stuff in China, so there's a limitation there. Of course, accusations of violations of intellectual property rights. But then there's also disrespect of multilateral organizations. We've seen how the US, has undermined the WTO rather than trying to work with the WTO, and has also not accepted if the WTO has issued rulings. I mean, they've accepted them, but now they're basically saying we're no longer happy to take that. It's therefore a selective interpretation of rules when it suits you and when it doesn't. And of course, this is situated in the overall context of the rise of China, where trade becomes now a matter of dispute, because in a sense one fears that, or the US in particular fears that China is becoming ever more powerful. It shows us that once you have rules in place, path dependency means that rules are very difficult to change, even though some members may regard them as dysfunctional. It also goes back to the question of the social construction of status. We had this dispute about great powers. Here it is about the attribution of developing country. It also shows us the difficulty to keep great power management in place if the states that are concerned as great powers are opposed. And it shows that there is often partial support for international norms, and that the rules then only, as we've seen already, the rules only cover aspects of the principles and norms. And this, of course, then creates frictions if there are others who say, hang on a second, but why don't we regulate other norms as well? So we've seen a challenge in the sense there's a tendency towards increasing institutionalization, but at the same time, so in terms of the pluralist international society is challenged through the increasing institutionalization and the reversal of the unanimity rule, etc. But we've seen also how states at the same time continue to play a central role in the regime. And we could see, therefore, the whole trade regime as an interesting case of a solidarist development, but not in a sort of solidarism in the sort of usual way we talk about it. So this is not human rights. This is an area where the norms are a lot more contested. So in sum, I've talked about how the GATT became the WTO, established then in 1995. I argued that this is based on liberal economic theory, where basic principle is the liberalization of trade through the three principles of non-discrimination. I've demonstrated how this moved from the regulation of industrial goods that move from A to B to the regulation of different trade aspects. We've seen how there's been the development of those rules through a mechanism of intergovernmental rounds, a typical way of organizing a regime. And we've noted how this has, with Doha, become very difficult because it doubles into areas where the different WTO members have very different ideas of where to go. Within the rules, we've seen the development of sort of a nearly supranational conflict regulation in the dispute settlement body, and in particular in the appellate court. We've seen how this is currently challenged, but how at the same time member states find it necessary to continue with alternative arrangement. We've noted how in the Doha round currently we are discussing aspect of commercial and social trade policy, and where the elimination of subsidies in agriculture is largely put forward by the global south versus the insistence in the global north to minimal standards of the conditions of production, in particular as far as working conditions and environmental conditions are concerned. The WTO, therefore, does not represent a substantial challenge to international society. States are at the core of this, but we can discuss it as one of the forms of solidarization in a field that is normally not discussed in those terms. And of course, as I said, the legitimization of all of this focuses a lot on output as economic growth. And this is, of course, dependent on your acceptance of liberal economic theory, which is contested and has uneven effects. And therefore, I suppose we will see continued contestation, and it's therefore perhaps no surprise that when we go back to the WTO Ministerial Conference, remember 1999, the Battle of Seattle, that was exactly, of course, a dispute that was brought forward in the context of the WTO. Thank you very much. Thank you for bearing with me. I'll see you next week on regional integration. I have about 500 slides, so I'll try and be as brief as possible.